Daniel, how are you?
I'm good. How are you doing?
I'm fine, thank you. It's your first time as my guest, so I'm very happy to have you as a guest today. And we're here to talk about a recent case that you won. Congratulations.
Oh, thank you.
It's a really interesting case. Not interesting for your client, unfortunately. I mean, the outcome was obviously good for your client, but what your client had to go through, unfortunately, was very, I mean, shocking. And it is a case that was recently published in the news. There was an article about it. I posted that on my socials. It is about police brutality, unfortunately, where you're going to be talking about what happened, but we will be talking about this problem again, yet again, where the police are acting in a very violent way towards people who are accused of crime. So, but before we get there, Daniel, if you can introduce yourself to my audience.
Sure. My name is Daniel Rechtshaffen. I'm a criminal defense lawyer. I got called to the bar in 2003, and I practice in downtown Toronto, about 50 feet from our new courthouse, in a shared chambers with a lot of other criminal lawyers.
And you do only a criminal?
Yeah, I mean, I do regulatory work. Anything that has a punishment attached to it, I deal with, but I don't do
Quasi-criminal
civil
as well.
litigation or anything like that. It's all criminal and quasi-criminal stuff.
All right.
Yeah.
So, Daniel, if you can tell us a bit about the case, some factual background for people who haven't read the article. And I know this case, there was a written decision, but it wasn't published. So people can't actually read yet or don't have access to the decision. So if you can just give us a bit of a factual background.
Sure. Yeah, I mean, Justice McHugh read the decision out. It was clearly a well-considered, lengthy decision, so it wasn't done off the cuff, but he has not supplied a copy of it. So at some point, I'm sure it'll be a copy of it will be produced. But essentially, the finding of the court is that my client was robbed of a certain sum of money, believed to be over $100,000. The judge made a finding that it was likely proceeds of crime. Uh, my client got wind that the person who stole the money uh, had attended at this apartment in London at some point. So he shows up there looking for the person who took the money. And when he's not there, he basically takes out a gun and suggests to the person in the apartment that he come with him to go and find the person who took the money. And as they are going through the underground parking garage of this building, the police appear, and th my client and the co-accused and the person from the apartment are all kind of lined up against a wall. And then as the police are dealing with detaining them, the garage door starts to lower. The police get distracted momentarily. And then the two co-accused kind of take off running through the garage. And the uh, the police set off a taser, which the police later who arrive said that they thought were gunshots being fired because of the way the sound echoed in the garage. So the police are under the impression that there's a gun involved and that a gun could have possibly been discharged. And so they have this in their mind as they're chasing my client and the co-accused. But as the two accused are being chased around a corner by these two police officers, they happen to arrive in a spot where there is a video camera overhead. And what we see is that as soon as they round that corner, there's five other police officers approach from in front of my client, including, and they all have their guns drawn, including the ones who are following them as well. And one of them has a C8 carbine rifle pointed at my client. And as soon as he sees that, he immediately gets down, puts his hands up, shows that he's surrendering, gets down on the ground. And despite his complying with the police order to get on the ground, he immediately starts to just have the absolute lights kicked out of him by the various officers. First, starting with an officer named Lacroix, who's the one with the rifle.
Mhm. And then what happened? Because it doesn't stop there.
Yeah, I mean, all the officers kind of take their turns,
Yeah.
uh, kind of uh, excessively beating on my client for no reason, and and then ultimately they get him in handcuffs and they search him and they recover a firearm, which was no surprise. I mean, the police came there knowing that there was a firearm that was involved. Um, and then even once the firearm has been recovered and he's in handcuffs, the same officer who kicked him first in the face grabs him by the hair and yanks his hair back. And you can really see him like writhing in pain on the camera. His head kind of shoots up towards the ceiling, and it's just all like completely extrajudicial punishment that the police are just meting out before he's even been charged with an offense. And so as a result of all that, we brought an application for a stay under Section 7, and it was granted because of how bad the abuse of force was.
So one of the things that I thought was pretty shocking from reading the article is that, as you mentioned, Daniel, this was captured, or parts of it was captured on video. So there's a video that shows the best evidence of what happened. But it seems that at trial, police officers testified in a way that was contradictory to what's on the video, which I find is also a little bit disappointing. You'd want the police officers, when they're confronted by a video, to say, yeah, it's true. Like, that's not what happened, or like, I messed up. But it doesn't seem like that was what the police officers were saying at trial, right?
Hmm. Yeah, I mean, the police falsified their notes. They said that my client was reaching into his waistband for a firearm. Uh, and they said that that was happening after he got down on the ground, which was clearly not what's shown
Yeah.
on the video. So they just stuck to that version that they put in their notes, despite the video evidence being extremely clear to the contrary. Um, anyway, so we could talk a lot about the implications of this, but the scary thing is, you have police in this case who are willing to so steadfastly stick to
Right.
this version of the events that they think helps the prosecution, even when there is a video. So it kind of raises the question, well, you know, how often does this happen when there is no video, right?
That's the thing. And I mean, we have to also remember that it's not, like for a very long time, we didn't have videos, or especially now there's body worn camera that really captures almost the entire interaction between the police and the accused. But that's relatively new in the practice. We didn't have the benefit of having the videos. Now, obviously, a video can go both ways. It could sometimes be even bad to the accused, but in some cases, it is revealing to be really beneficial because our clients will tell us something that happened, but then when we read the police notes, they don't reflect what the accused is saying. But sometimes when there is a video, we see that no, what the clients are saying is true. And the problem here is that why are police officers just, because it raises concerns about the accuracy of their notes and what they're putting in there. And it seems like they're just not telling necessarily the truth in their notes, but that's pretty scary.
Yeah, I mean, listen, I started practicing before cell phones, like what cell phone cameras were a real thing. Like, I had a cell phone when I started my practice, but the camera on that was like a 1 megapixel camera. Like you couldn't take my first cell phone, I don't even know if it could take video. I don't remember. I think it could take video, but it was like, incredibly grainy and like whatever. So, it wasn't really until the iPhone that, so that's 2017 or 2007, I believe, when you had like a camera in your pocket that could really in high definition capture events. And that was a game changer for, evidence in courts because it's not just that maybe get lucky and there's a surveillance camera. It's that, everyone has the ability to videotape everything all the time now. So I think that was the first step in judges really being willing to open their minds to the fact that the police are lying about this stuff sometimes. Because before that, it was like, it was sort of like, well, why would the police lie? They swore an oath to tell the truth. And they were treated as a different class of witness
Yeah,
in terms of sort of a
very true.
baseline credibility.
Very true. That it seems like when it comes from a police officer, that they're almost like professional witnesses. That's what they do. It's part of their job to go to court and to testify. And judges would prefer their evidence over that of the accused if there were any conflicts. But now with these videos, especially the body-worn camera, is also a game changer because it really captures the interaction between the officer and the witnesses and the accused. And they clearly sometimes show that there is a discrepancy and a contradiction between what actually happened and what the officer writes in their notes. And it's scary to realize that officers don't necessarily, well, sometimes they don't even mention some things that are important that we see on the video. They don't even bother to write them down, or even when they do write things down, it's not really what happened. And makes me
Mm,
wonder how many cases have we had in the past where the officer's evidence was accepted by the court and it wasn't actually the truth. I mean, that's scary, no? To think about
right.
that.
Yeah, well, I mean, there was like a whole era of like what they used to call dropsy cases. So, I mean, my practice is primarily wiretap surveillance, Gare Foley's drugs, guns, that kind of stuff. I mean, I do everything, but that's like my number one thing. And there used to be these cases they call dropsy cases where the police would say that they approach someone and the police say, okay, as soon as I approached this guy, he got freaked out and threw his drugs on the ground. And those cases, eventually they started getting challenged, and judges kind of stopped believing that that was really happening. And then the police just adapted their techniques. They stopped saying that people were throwing their drugs on the ground. And I mean, that was Edward Sapiano was one of the lawyers who kind of like led the challenge to that and sort of opened the judge's eyes to that. So like that was not based on video evidence, but it was another example of how the police would give this evidence that was just kind of universally accepted. And then there were this moment where the court was like, oh, maybe this isn't what's really happening.
Yeah,
But I mean, the scary thing about this is like, you know, uh, there's plenty of judges who are I'm not taking the position that every police officer is automatically lying in every case,
yeah, of
obviously.
course.
But the challenge is like there are still plenty of judges who uh, are very, very loath to consider the possibility that the police are being untruthful. And the challenge for us is it's really hard to prove
Yeah.
a lot of the times because we're not there. We don't have evidence often. And so trying to generate some independent evidence is one of the biggest challenges, right?
Right. And this is like another area that I'm sure you also know. Uh, it's the same thing with racial profiling. It's very difficult to prove. It's one of these things that the courts have recognized that it does exist, unfortunately, but it's very difficult to prove because you're rarely going to have direct evidence of that. You're not going to have a police officer who's going to admit that he's racist or that he was driven by racial biases. Uh,
Right.
and yet we can see through the action and the interaction with the accused that there's clearly something there. So it is clearly a difficult thing to prove. But the other problem in this case that you had as well. So there are two layers. There's what we just talked about the police interaction, but then the Crown. The Crown made comments that a lot of people I saw on social media were commenting about that, being shocked by how can the Crown say things like what was said in this case. So if we could talk a little bit more about that, because like crowns at the end of the day are ministers of justice. They're not defending anyone. They're just defending the public interest. They're not representing a client. And you'd expect that when the case is unfolding and it becomes apparent that there is a problem, even if it's from the police, that the crowns should, as ministers of justice, say, okay, Your Honor, this is problematic here, and you should probably that they would recommend that the charges be stayed. But that's not what happened here, right?
That's definitely not what happened. Um, Look, to get to the point of the trial in this case, there were some significant pretrial battles that had to happen. I was fighting for disclosure for a long time. More than one disclosure application was brought. Uh, one of the big issues is the police didn't perform a meaningful use of force review of this case until I brought my charter application. That was 15 months after the fact. And the London police top brass were concerned with this case because there were emails back and forth between the deputy chief and other high-ranking officials within the London Police Service. And then they got the use of force trainer to create a review. And the use of force trainer reviewed what was done, uh, with the exception of one, I believe, one single kick. Uh, Basically had no problem with it. And more to the point, more concerning, is that in that use of force review, the use of force trainer didn't seem to somehow see a discrepancy between what was shown on the video and what was in the notes. So, I mean, this is the person who's training on use of
Yeah,
force, and you would hope that when that person reviewed the video and reviewed the notes, that,
you would
he would
acknowledge that
notice
there's
that there's a
a problem.
problem.
Yeah,
So, I mean, I can tell you that in fighting for that disclosure, my submissions to the court were that the Crown should be as concerned
yeah,
with this being released as I am,
yeah.
because the Crown has a role as a Minister of Justice and should want, all of this to be provided so we can get the best evidence, so the court can make an informed decision. Um, if I were the Crown, I certainly I would never be a Crown. It's just not in my nature. But if I could imagine myself in that position, for myself, I would imagine that my first position would be it should be stayed. It's clearly excessive use of
Right.
force. It's clearly something that would shock the public conscience. It's clearly something where the importance of the court distancing itself from this kind of conduct outweighs, the interest in trying the case on the merits. But if that somehow weren't my position, my fallback position would be to argue, well, yes, there is excessive force here, but maybe it doesn't rise to the level that it
Level
should
up
be a
and
stay.
stay. Right.
But to suggest that, the officers were uh that they held that an honestly held belief that my client was, for example, reaching for his firearm uh when he clearly wasn't, or when the officers gave testimony that my client's hand was free and it created a danger because he could reach for a gun when his all of his appendages were being either held or stood upon by police. I mean, it's clearly what they were saying was not truthful. So, for me, if I were in that position, it it wouldn't be my choice to uh, try and bolster the legitimacy of those stated beliefs by the police. That's not how I would have done it, but
Well, and you're absolutely right. This is how it should be. I mean, there was this recent Supreme Court case of McKee where it was also about disclosure about the police records, where in that case, from my understanding, the Crown was pretty much concerned and thought that it should be disclosed. And that's how you want the Crown to be. You want them to, when they see that there is something that is problematic, even if it doesn't even if it weakens their case, that they would be honest about it and acknowledge it. But to continue and just kind of deny or just act like it's not a problem is what I mean, I find, maybe because I'm a defense lawyer, but I would also think is a bit shocking. I mean, we had a case not a long time ago in Toronto, not in London, where the Crown got really mad when a police officer was being honest when he was testifying in court and saying, well, he then told the Crown when she confronted him, like, what do you want me to do, to lie? And she was like, well, we defend our own, or something to that effect. So it's problematic, and it seems like it's not just in London or just in Toronto. It seems like it's pretty commonplace.
Yeah, I mean, look, I've been doing this a long time. I've dealt with a lot of different crowns, and I I will like to think that most of the crowns understand what their role is and execute it faithfully and are mindful of the public interest. And that's my experience. That the crowns who are doing their job properly do that. And you know, uh, I am, heartened by the fact that I deal with crowns every day who understand that role and take it seriously and act in the best traditions of the bar. I'm not going to use this time on this podcast in this interview to slam the crown in this case in London. The reality is, I mean, the comments that she made are some of them are public now as a result of the
Article.
articles that were written. Um, you know, I um I think that the Crown and I had a very different view of how serious the misconduct was in this case. For me, we had to call a dental expert to talk about the extent of the injuries. And this is a young man who was 19 years old
Mm.
at the time that this happened, who had no pre-existing dental issues, his perfectly healthy young
Wow.
man, who had his face demolished by multiple police officers. His mouth will never be the same because of this. And I don't care what you have done or the police think that you've done. We have a process here. There's a court system that sorts out innocence and guilt and then metes out punishment if you're found guilty beyond a reasonable doubt through the proper channels. And what the police clearly did here was just short circuit that entire process and front loaded this incident with punishment at the beginning. So, I have no tolerance for that. We as a society should have no tolerance for that. And I think that's the message that this judgment sends, right?
Right. No, I totally agree, and it's really the right message that should be sent here. And because one of the other problems that we have in criminal law, and that sometimes we see that from some kind of public reaction, some from members of the public, is sometimes even when there's a mention of brutality in a case, people will say, well, but it's okay because the person is a criminal. Like, it seems like if someone is a criminal or and in this case accused, or he wasn't even charged at this point, your client, right? That was even before the arrest and before he was being charged. And so people will look at this case and say, well, okay, but he had a gun, so it's okay if we treat them this way. And that is what I find is problematic, is when you don't treat a human being as a human being based on allegations or thoughts or because of things that they did. And that is what is concerning. And in your case, he's 19. Like, not like 2 years ago, he was a child, like he was a youth.
Mhm.
So it's really a problem. I find that people need to understand that even if someone is accused or there are allegations of criminality, that doesn't rob them away from their humanity. They still are entitled to be treated like human beings. And when they're not, that's the problem. And when people are not shocked by that, that's the problem. And I think that's what we try to do as defense lawyers in our job, is to let people realize that these are human beings. They should still be treated the same way as everyone else, even if they're accused of a crime. Like, that's what is your view on that, on how people react to, because he's a criminal, so it's okay if he gets bad treatment?
Yeah. I mean, look, I understand the perspective. And, you see comments when an article like this comes out, you see
Yeah.
comments. And one of the things that people like to say is, well, like two wrongs don't make a right.
Mhm.
So, yeah, the police did this and they should be punished for what they did. If they lied under oath, they should be charged with perjury and, they should lose their jobs and whatever else. Or, they should be charged with aggravated assault or whatever it is. But this guy should still be tried because he still, kidnapped this guy and still had a gun and whatever. But, I think as defense lawyers, part of the obligation that we have, the role is to help educate the public. Um, and not because like we're elite and better, but this is our job. Like we, have an insight into this that people maybe just don't realize because it's just not something they interact with every day, especially people who don't get charged with crimes. They have no familiarity with the criminal justice system other than what they see on TV. So, um, the way I like to explain it is I like to say, I was thinking about this. I was on vacation recently and I was in a place where I was, another criminal lawyer was there with me and we were talking about the fact that, in this particular place, there's like shakedowns and things like this. And, it's a thing that we kind of say and take for granted, but the idea that you have a functioning justice system where if you have a problem, you have recourse. Like there's a police service that has integrity, that can be trusted, that will investigate according to the letter of the law. And then there's a court system that will try you according to the letter of the law. Um, that means you have a society.
Yeah,
If you don't have those things, like, the same people who scream for law and order and want punishment for criminals, those people have to understand that that system they want to punish people won't exist if we don't protect it. And
right.
this is how we protect it. We protect it by making sure that it functions fairly and that we only find people guilty when they're proven guilty beyond a reasonable doubt. And we don't allow the police to just run you know, uh, their own trials as judge, jury, and executioner before the person's even stepped foot inside of a courtroom.
Mhm.
And so, those two things are not separate concepts. They work together, and the system only is there to be able to provide punishment or whatever it is that you want in response to crimes being committed if there's public trust in the institution and that the institution, meaning the judges sitting in the courts and the crowns prosecuting the cases, can make the difficult decisions that allow respect for the system and functioning of the system to be maintained. So, yeah.
I totally agree. And honestly, as you said, Daniel, trust in the system is really very important, and that's why I mean, this case is one example of how people can lose trust in the police. It's when they have these types of interactions, and even if assuming that there was some kind of force that should have been used, that was clearly excessive in this case, and it wasn't properly used. And that goes to each and every officer's discretion. I mean, I don't know if it's a training problem though with the police, or if it's just an individual problem. But I mean, here at the end, there was more than one police officer who got in and did the same thing as well. It wasn't just one. So it seems like it's also a culture problem a bit with the police. Uh, One police officer will say something and then they all jump in and do the same thing together. It's a little bit problematic. Like they need to operate on more information. And again, I know that some people will say and defend the cops and say, well, they were acting in the heat of the moment, like they don't have time to analyze everything. But still, like they were dealing with someone who's rather young, and they also have weapons with them. It's true that your client had a weapon, but police officers also. So it was kind of equal. It's not like he was armed, they weren't. So I mean, it's a whole situation of balance of power, discretion, and how discretion is being used, and just added to that the trust that we need to have with the police officers. So I mean, it's like so many questions have been raised in this case, and it just shows some of the problems that we have. But I wanted to also ask you, from this case, like from the issues that came out of this case, what do you think would be a way? Because we've been starting to see a bit more and more of them in the media being covered, these types of cases of police brutality. But what do you think is something that needs to be done so that we have less of these cases?
Well, I mean, I'll start by saying that I sympathize with the police having to go into a situation where there's a call for a gun and it is, a dynamic situation where, anything could theoretically happen. The problem in this case was that the police officers were talking about, there was an officer who actually said during the trial that that someone can act faster than I can react. So suggesting, like, even though there was no evidence that my client was actually reaching for a gun, that he was essentially pre-acting to an imagined action that he thought my client was going to take. And that's not what the training dictates that you're supposed to do. You're not supposed to go in there and run a bunch of imaginary scenarios of my client reaching for a firearm and react to them as if they're actually happening. So there's a fundamental issue whether it's with, I'm not sure that's with training, because they're not trained to do that. I
It feels like it's over policing. It's like doing more than what the situation requires them to do.
Yeah, I mean, the thing that the police say is that, they're reacting and they're basically not timing their responses to a night with a nicety, because, it's this like high pressure situation. But the reality is, without going to too much of the details of the like specifics of this case, the reality is that there were 7 police officers who had firearms pointed at my client.
Yeah.
So like there's so many ways in which if there was a possibility of that escalating, it could have been mitigated without the police having to go anywhere even near my client.
Yeah.
And if he had truly been reaching into his waistband for a firearm, I truly believe that he would have been dead.
Mhm.
The police would have just shot him, and that would have been the end of it. And the evidence the officers gave, in particular, one of the officers basically said as much, and admitted that at a certain point, he didn't believe that it was a risk to him, for the reason that there were guns trained on these guys. So, I think part of the issue is that, um, until there's some kind of consequence for this kind of behavior, it's going to continue. Like
Yeah.
what we see time and time again is the police, you know, get caught doing things they're not supposed to be doing, and it in no way interferes with their ability to ultimately get promoted, move through the ranks, and then eventually retire on a public pension. So, from my perspective, uh, we can talk about the what I think is really even arguably even the more serious issue here. The police brutality is serious, but coming to court, falsifying your notes and coming to court
Yeah.
and swearing an oath or taking an affirmation to be truthful and then lying. I mean, how does this? So if these officers don't get fired, like how do they ever testify in a trial again? If when next time I see these guys in
Yeah.
trial, like this is gonna come up.
Mhm.
So, the case law is very clear. While I'm not allowed to question a witness about the findings of a judge, the reason why they ruled that they were being untruthful, I can certainly put to them that, they testified in a particular way, and in fact, that wasn't true. So the factual uh, element of them actually coming into court and lying, that's fair game for me to cross-examine on. And it's going to come up in every single case. Any lawyer who's doing their job, who has these guys on any case going forward, is going to bring this up, right? So how can they be effective witnesses in any case? How can they effectively be called upon to recount what they did in a criminal proceeding, in an investigation. Like it's tainted as far as I'm concerned.
Well, and we also have that recent Supreme Court case that also tells us that we have the right now to ask for their records, their convictions, and the problems that they had. And that I think is an important development because it is important to know how they testified on previous cases, especially charter cases, because those are the ones where police officers testify the most, and they depend heavily on the police officers' credibility. And like how they testify at trial. So it is really an important point here that you're raising that whatever happens or how what the outcome of these cases are, it's important to use that for future cases when we're dealing with these officers again, because then it will raise some concerns about whether they're telling the truth, especially like in this case, it turned out that they weren't telling the truth, and you had video to show that.
Yeah, I mean, you're talking about the McKee
Right.
decision that came out last month. It's not the McKee clarifies McNeil, but it's not setting new rules really. I mean, the interpretation that the Supreme Court has given to McNeil through McKee is the interpretation I always put on it, which is if the police are aware of something that could, isn't clearly irrelevant, it's not, they give the example of like if someone showed up late for work, something like that, that's not something you'd be
Right.
entitled to. But uh, from my perspective, like something like this, which the police clearly would know about, that's something that they've always been obligated to tell the Crown exists and to give to the Crown so that the Crown can vet it. I mean, what the one thing that McKee says is it's not up to the police. They don't get to gatekeep this. They don't get to
Right.
screen it. They have to give everything to the Crown, and then the Crown makes a decision about what gets given to the defense. But my position was that they always were supposed to give this out, and this has always been clearly something of this nature would have always been relevant to credibility.
But
But
whether
it's
we
not in practice. It's not. It hasn't been
we're not
happening.
getting it. You're right.
Yeah,
But the problem is, are we going to get it eventually because of the filters it has to go through? But then the other issue that we have, though, is that it depends also on the Crown. Like if in McKee, like the Crown was honest and felt that it should go to the defense and resisted and was trying actually to be fair and to make this happen, but the police were resisting. But if it was a different Crown, maybe they would have had a different approach that they would want to side with the police and be like, no, we're not going to disclose it, although it should be. So there is a little bit of discretion in how the individual is using their discretion. It's up to that as well. So it depends on who you're dealing with.
yeah, that's true. I mean, that's the funny thing about like just as a broader aside. I
Right,
mean, that's the kind of crazy thing about this job is that the
right.
outcomes are so variable
Yeah,
based on the individual's
exactly.
like crown judge, etc., defense lawyer. And it shouldn't be. I mean,
I
it
totally agree.
should be that same set of facts, you know, it should
Regardless of who the person is, you should get the same outcome. That's why I keep saying maybe AI ultimately is going to be ruling everything. We're going to have AI crowns and AI judges. I don't think you can have AI defense lawyers. You need a human being defending your rights, but maybe the ultimate decision has to come from AI, like whether it's on the crown, what should be disclosed, what shouldn't be disclosed. There shouldn't be any emotional aspect to it.
right. Yeah.
Maybe.
No, I listen, there's an argument there for sure to be made potentially. Yeah.
Yeah, I really think AI is going to be replacing everything almost. And who knows? Maybe this interview will be AI done in the future. We'll see. All right. Well, Daniel, I want to thank you very much. I know you've been very busy, so thank you for taking the time
Oh,
to
my pleasure.
talk to me about this case. Again, congratulations.
Oh,
Really
thank
good
you.
job here in what you did and the fight, because you mentioned that before you got to this trial, there were many battles on the disclosure level. So really good job. And I hope that we'll have another interview soon when you win another awesome case like this one, and we'll
Yeah, it's
talk
my
more
pleasure.
about it. Thank you
Yeah.
so much.
Thanks for having me. I appreciate it.